Good afternoon, everyone. Welcome to our second event in the Congressional Series for Sutherland Institute. My name is Aaron Taylor, and I serve as the Executive Vice President for Sutherland Institute. As our CEO, Rick Larson, has stated, we are proud to continue in the tradition of bringing Utah's delegation closer to their constituents on a topic that is of priority to them. Our goal is to facilitate engagement and civil dialogue as our delegation members speak on a range of critical issues. Today, we welcome our second speaker in the series, Senator Mike Lee. Senator Lee is now serving his second term as Senator for the state of Utah. He serves on the Senate Judiciary Committee, the Senate Energy and Natural Resources Committee, as well as the Commerce, Science, and Transportation Committee. And he currently serves as the chairman of the Joint Economic Committee. Senator Lee will be speaking on the Supreme Court and religious liberty, the top court's impact this term. Senator Lee has a hard stop this afternoon at 3:30 our time, so we will only likely have time for one question or two at the end. Senator Lee, thank you again for joining us, and the time is now yours. Senator Lee, can you hear me?
Here we go. Okay, I think we're on now. Thank you very much for inviting me to join you. Thank you. And thanks for all you do through the Sutherland Institute. I'm a big fan and always appreciate the insights that you offer. And I also enjoy your efforts to connect members of Utah's congressional delegation with voters throughout Utah. I wanted to talk to you about religious freedom today, and specifically about a small handful of cases that have been addressed by the Supreme Court this year that deal with religious freedom. I'm going to talk about two cases that were decided on the merits that are quite significant, and I think will be for some time. And then I'm going to refer to a third case, sort of a near miss, before we take any questions that you may have. First case I wanted to address is the case known as Our Lady of Guadalupe, which is short for Our Lady of Guadalupe School versus Morrissey Beru. This was decided by the Supreme Court toward the end of the term on July 8th of this year. This was a 7-2 decision in which Justice Alito wrote for the court. There were only two members in the dissent, Justice Sotomayor and Justice Ginsburg. The holding in this case was essentially that the First Amendment protects the right of religious schools and places of worship and other religious ministries to choose personnel, choose who performs vital religious duties. There's something known as the Ministerial Exception that protects the right of churches and religious institutions to choose their ministers, their leaders, and teachers of faith, requiring courts to stay out of employment disputes involving teachers of faith at religious schools. This frequently arises in employment discrimination cases, for example, where a religious institution will say to the federal courts, "You've got to stay out. This is our domain." Now, Justice Alito, in writing the opinion for the majority of the court, summarized the underlying issue as follows. He said, quote, "When a school with a religious mission entrusts a teacher with the responsibility of educating and forming students in the faith, judicial intervention into disputes between the school and the teacher threatens the school's independence in a way that the First Amendment does not allow." Now, Justice Alito correctly admonished the Ninth Circuit's three-judge panel, which issued the decision that was being challenged in front of the Supreme Court, for improperly minimizing and sort of casting aside or dismissing the importance of a teacher's participation in religious instruction just because she taught various subjects, including but not limited to religion. So she taught a number of topics, including religion, but not limited to that, from a textbook citing an amicus curiae or friend of the court brief. This was a great moment for me in that Justice Alito, in a majority opinion for the court, cited my brief. I previously served as his law clerk twice, first when he was on the Third Circuit and then after he went on to the Supreme Court. I filed an amicus brief along with 28 other members of Congress, and he cited that brief in his opinion. As many of you know, religious elementary and secondary schools curriculum often weaves religious themes and religious teachings into subjects other than strictly theology. And teachers, especially elementary school teachers, often teach every subject, including religious doctrinal issues, to their classes. So religious instruction provided by a third grade teacher, as was at issue here, is almost indistinguishable from that of a religion teacher or a minister. And that's why it was important for the Supreme Court to invoke this so-called ministerial exemption in this case, in the Our Lady of Guadalupe case. The other case I wanted to talk to you about today is known as the Espinosa case, or Espinosa versus Montana Department of Revenue. This was decided just about a week before Our Lady of Guadalupe on June 30th. In this opinion, it was a 5-4 decision in a majority opinion authored by Chief Justice Roberts and joined by Justices Alito, Gorsuch, and Kavanaugh. The dissent was written by Justice Ginsburg, and she was joined by Justice Kagan, Justice Breyer, and Justice Sotomayor. The holding in this case was that the Free Exercise Clause prohibits Montana from excluding religious schools from participating equally in the state's scholarship program for low-income students. In this case, the Supreme Court held that the government may not constitutionally legally discriminate against religious schools that serve the same function as secular schools just because they are religious. In other words, it may not discriminate on the basis of religiosity. This decision, in that respect, is a big win for low-income students in Montana who would benefit from the scholarship program to attend the school of their choice. And it has the potential, indeed, I would say the inevitability of becoming a win for others elsewhere. Now, Chief Justice Roberts' majority opinion expands the court's previous decision, I think from 2012, in the Trinity Lutheran case, where the Supreme Court found that a state program to improve playgrounds that denied funds to churches constituted religious status discrimination by finding religious status discrimination existed where a low-income scholarship program denied scholarships to religious schools. So this is a decision that significantly limits the application of Montana's Blaine Amendment and similar Blaine amendments in the 38 states where they're still on the books. And as most of you are aware, Blaine amendments are language that was inserted into the state constitutions in many states about about a century ago, in order to limit the influence of religious institutions on the school systems. And in some states, the Blaine amendments have been interpreted very narrowly, very strictly. And so what the Supreme Court has said is, regardless of what your Blaine amendment says, you may not engage in religious status discrimination. That is, you can't find that a religious institution is ineligible to participate in an otherwise generally available government program simply because of the fact that they are religious. So those are the two cases that were addressed on the merits. I told you I wanted to mention one other case that I refer to as a near miss. That was the Calvary Chapel case. Calvary Chapel versus Sislyak. This is the Nevada case that was decided, or I guess it's better to say not decided, a few weeks ago. On July 24th, the Supreme Court declined to enjoin a lower court ruling that was geared toward taking down and acknowledging the unconstitutionality of a Nevada law restricting conduct within a church. Nevada's law, as written and implemented, contains one set of COVID-19 related standards that apply to churches, and it's a more rigorous standard than the more permissive standard that applies to other businesses, establishments, including casinos. And this ends up creating a problem. Now, we had 4 members of the Supreme Court who dissented from the denial of this injunction, of this stay application in this case. Justice Alito, Justice Thomas, Justice Gorsuch, and Justice Kavanaugh. Justices Alito, Kavanaugh, and Gorsuch each wrote separate dissents from the denial of this relief. The most concise and brief of the 3 was written by Justice Gorsuch, and I thought I'd share that with you briefly. He summarizes it in a single paragraph in which he says, this is a simple case. Under the government's edict, a 10-screen multiplex may host 500 moviegoers at any time. A casino, too, may cater to hundreds at once, with perhaps 600 people, each huddled at craps tables here and there, and a similar number gathered around every roulette wheel there. Large numbers and close quarters are fine in such places, but churches, synagogues, and mosques are banned from admitting more than 50 worshipers, no matter how large the building, no matter how distant the individuals, how many wear face masks, no matter the precautions at all. In Nevada, it seems, it is better to be in entertainment than religion. Maybe that's nothing new, but the First Amendment prohibits such obvious discrimination against the exercise of religion. The world we inhabit today, with the pandemic upon us, poses unusual challenges, but there is no world in which the Constitution permits Nevada to favor Caesar's Palace over Calvary Chapel. So I think that very brief very brief dissent from the denial of relief in that case demonstrated something very significant. Any 5 members of the court could have voted to grant the injunction against the implementation and enforcement of the Nevada law being implemented that was subject to the challenge there. The fact that there were 4 frequent advocates and defenders of religious freedom who were willing to stand behind that position, that is Justices Alito, Thomas, Gorsuch, and Kavanaugh. The fact that the 4 of them were willing to speak out and the other frequent defender of religious freedom, Chief Justice Roberts, was not, is significant, and I find it disconcerting. In any event, I think it was a near miss. It was a really significant missed opportunity. As Justice Gorsuch put it, there really is no world in which that can be constitutional. That's why I find it somewhat perplexing, because they're not willing to defend it on the merits. And I'll die of shock if at the end of the day, the Supreme Court stands a decision on the merits of that case that the Nevada law is okay. And it's therefore puzzling that they didn't grant the injunction that was sought here. With that, I'd love to answer any questions you may have.
Excellent. Thank you so much, Senator. Let me go to your first comment on the educational case. And you mentioned the Blaine amendments, something we're very familiar with here. What do you see as the future of the Blaine amendments? And how do you see that impact? Is that something you think the Supreme Court will ultimately be ruling against in the future? How do you see that rolling out?
Yeah, I don't think that Blaine amendments have a very strong future. That is to say, I'm not predicting that Blaine amendments will be deemed unconstitutional as a whole. They certainly don't, I don't see them as being struck down as facially invalid, because in order to meet that standard under United States versus Salerno, it would have to be established that they're unconstitutional in all of their applications. Blaine amendments are capable of being implemented and applied in a constitutional fashion. But in many circumstances, they may run afoul in an as-applied challenge in light of this more recent precedent. I think you'll see Blaine amendments increasingly being narrowed as a result of this decision. And certainly you won't see selective religious-based discrimination against a particular school or religious enterprise based solely on the religious nature.
Thank you for the insight. That's helpful. Let me turn to the second topic you mentioned on religious liberty. You recently wrote a letter about state and local government restrictions. Can you give us more insight into what prompted that letter and how you see the Supreme Court case that you mentioned, what impact it might have on institutions within the state of Utah, such as BYU?
Yeah, a number of us have asked officials within the Trump administration, including Attorney General Barr, to look into whether and to what extent religious liberties are being infringed as a result of COVID-19 activities. Now, to be very clear, under Employment Division versus Smith, the government has power to, governments, including states and localities, have authority to adopt and implement and enforce generally applicable religiously neutral rules governing health and safety issues and so forth. So there's nothing, as with the Blaine Amendment, there's nothing categorically constitutionally problematic or unconstitutional about COVID-19 response efforts or legislation directing that certain sectors of the economy be subject to certain restrictions. There is, however, a big problem with the selective implementation and enforcement of those mechanisms. If you remember in Kentucky a few months ago, there was an issue with drive-by church being excluded, and church was being specifically excluded from a list of other activities that were permitted. That's where government runs afoul. That's where you run into First Amendment problems. That's where you end up violating religious freedom, is where you identify a rule of general applicability that is imbued with religious neutrality, and then you implement it selectively as between religion and irreligion, or as between one particular religious viewpoint or denomination and another.
Okay. As a reminder for our audience, you are listening to Senator Mike Lee speak on the Supreme Court and their recent decisions this term. My name is Aaron Taylor. I serve as the Executive Vice President for Sutherland Institute, and we're now in our Q&A session. Senator, let me ask you this question. Do you see the cancel culture and freedom of speech issues as having a spillover effect on religious liberty?
Certainly can, and I think anytime you see populist movement of any sort, regardless of its objective, if it's a populist movement that gains a lot of popularity and there is a sudden groundswell or uprising, whether at the polls or in the public square, and that uprising, especially where that uprising results in government assuming more power in order to address whatever the uprising is, or in this case, in order to respond to demands of certain groups or entities, asking for a government response to cancel culture, or enlisting the government's assistance in canceling unpopular ideas. Anytime you see government authority expanding, there is necessarily a corresponding risk to liberty. Sometimes that means liberty generally, or liberty of one sort or another. It almost always includes an encroachment into religious freedom. As I sometimes say, you know, when Godzilla steps on your house, Godzilla is not necessarily doing so because Godzilla sees you and has singled out you for treatment, either because he hates you or he thinks you look particularly tasty when compared to other people. No, when Godzilla steps on your house, most of the time, you know, it happens from time to time. It's because Godzilla is huge, and your house happens to be in the way, and he's clumsy. I was giving that remark once, and someone pointed out to me it could just as easily be the Stay Puft Marshmallow Man, as seen in one of the final scenes of the original Ghostbusters movie, where he starts walking down a street in New York, I believe, and this giant 10-story high Stay Puft Marshmallow Man steps on a church, thus prompting the Ghostbusters to aim their weapons at the giant Stay Puft Marshmallow Man, shouting the words, "Nobody steps on a church in my town." This is what government is like. When government gets big, government gets clumsy, it inevitably becomes reckless of individual liberties. And that is certainly true with religious liberty. We've got to be on the lookout for that.
Okay. Here's one more on religious liberty, coming from the audience. Some people wonder if religious freedom harms other groups or even the non-religious. Others say religious liberty protects everyone. How do you respond to that?
Okay. Religious liberty has to be revered and respected as a concept, independently of utility to any one individual or any one group. So I suppose the same critique could be raised of expressive liberty, of freedom of speech, freedom of association, freedom of the press. You could say that in some circumstances, the exercise of any one of those liberties could come at the expense of somebody else. That doesn't make it okay to trample. Quite to the contrary, it is the unpopularity of minority views, whether they're religiously minority views, politically minority views, or otherwise. It's the exercise of these rights that we've decided as a society to protect. That's the whole reason to have a constitution, in fact, is to limit the power of government, because governments are powerful. Governments are, by their very nature, neither omnipotent nor omniscient. They are simply organized, collective, official, coercive force. So we've decided as a society that there are certain kinds of things that governments must not do, must never do. And one of them is just, extinguish expressive conduct or speech or the rights to freedom of the press. And another is the free exercise of religion. So here as there, just because someone doesn't like it, just because somebody might feel like the exercise of those rights runs contrary to what they would like to see, or maybe even runs contrary to their interests, that still doesn't make it okay for government to interfere with that right. We've taken that off the table as a matter of constitutional law. And so we're not really at liberty to just decide that because a certain set of religious beliefs might be inconvenient or offensive to some people, that we're going to squelch
them. Excellent. And I know we only have a few minutes left. But let me ask you one last question relating to judicial activism. Do you believe that is the impulse toward judicial activism something that can truly be overcome by simply nominating better justices? Or does it require an exercise of constitutional checks and balances on the court's authority? Put another way, is the drive to make the law built into the human nature of the justices themselves, and therefore something that better vetting cannot overcome? And what does that mean for legal conservatives who believe in judicial restraint?
Okay, first of all, I want to say a word about judicial activism to frame my answer. The short answer to your question is, I think it takes both, but I want to be clear about what I mean. The impulse, including the impulse by many on the right, many people like me, is often to decry judicial activism. In many ways, it's not just activism that is concerning. When we focus excessively or exclusively on judicial activism, we ignore the evil twin brother of activism, which is passivity. In other words, it is equally bad when a jurist decides to use judicial power in order to invalidate a constitutionally legitimate law, we'd call that activism, as it is for a jurist to decline to invalidate as unconstitutional, something that is in fact unconstitutional. In other words, the impulse that we're after, the norm that we're after, the aspiration that we should have as a society is to have neither judicial activism nor judicial passivity. It is equally repugnant to the Constitution and to our system of laws, to our constitutional republican form of government, to have a jurist act where he or she shouldn't, or fail to act where he or she should. That gets back to your question, then how then do we do that? I don't think it can be done solely by means of selecting better judges. I think some of that can be, and that when we go out of our way to look for jurists who understand the difference between will and judgment, as articulated by Alexander Hamilton in Federalist 78, explaining that will is something exercised by the political branches of government, especially the legislative branch. It is forward thinking, it is norm setting. It talks about what should be. The judicial power is about judgment. It's rear view mirror looking. It's looking at what has been, what the law is or was or has been as of the date or dates relevant to a particular dispute properly before the jurisdiction of the courts. So we do need to find people who understand the fundamental differences between will and judgment, between Article 2 power in the executive, Article 1 power in the legislative branch, and Article 3 power in the courts. But that can't be the sole thing that does it, because without a society, without a system of government, without the two political branches also having a commitment to sound lawmaking and to making sure that the laws are implemented and written in a way that's respectful of the Constitution, the courts can't save us. The courts can buy us time, but they're sort of like the pumps on the Titanic. They can delay the sinking of the ship for a while, but you can't save the ship unless you've got all three branches of government functioning properly.
Thank you again. And Senator, on behalf of, I know we're running up against your hard stop at 5:30 DC time. On behalf of all of our audience, I know they have enjoyed listening to this. And I would just like to remind our audience that our next series will be with Representative Ben McAdams on Monday, August 10th at 11 a.m. Mountain Standard Time. Senator, thank you so much for your time and for your willingness to speak with us and answer these questions.
Thanks so much, Aaron.
Have a great day.
Thank you.